Chapter 4: The Subjects of International Law. 4.1. International Legal Personality. The law will determines the nature and scope of personality, and this holds true for international law as it holds true for national law. When we say subject of international law, we will be talking about a body or entity that is capable of exercising and possessing rights and duties under international law. Thus, it is international law that devotes the ability to act within the system of international law. International law defines the criteria and which at the end of the day. So when we talk about international legal personality, we are talking about entities getting legal personality as being capable of having rights and duties and having the capacity to enforce it. One distinguishing characteristic of modern international law is that more and more subjects are gaining personality under international law. Traditionally, states were the only subjects of international law. After the end of the Second World War, new non-state actors of international law have joined the group. However, the orthodox positivist view still maintains that states are the only subjects of international law. This theory is an obsolete and outdated concept in the contemporary world. Nevertheless, despite the increased involvement of non-state actors in the international legal system, states remain by far the most important legal actors, subject of international law. This is due to the existence of varying degree of personality. In international law, there are two types of personality: original personality and derived personality. When we say original personality, we are referring to personality that entitles to all sets of rights and duties under international law, and it is states and states only who are recognized as having international legal personality. Derived personality entitles subjects, actors to limited rights and duties, plus, as the name itself indicates, is derived from the will and consent of states. If we take, for example, international organizations such as the UN, it was created by states. And even if it was created, it could have been left with no legal personality. When we are talking about legal personality, we are talking about legal personality that would be obtained because states consented for that. 27. PHE. Personality to be conferred on that entity. This tells us that legal personality under international law is relative. It's only states that have the totality of rights. States as typical legal persons. 1. Creation of statehood. Q. When does an entity qualify as a state? Do you think membership to the UN implies automatic statehood? Only states could be members to the UN according to the UN Charter. However, since politics plays a huge role, there were times when countries who did not meet the requirements of statehood were admitted as members to the UN. Countries like Pakistan, India was admitted even before its independence from British rule could be cited as examples to this. Membership alone doesn't imply automatic statehood, however, currently being admitted into the UN is a strong evidence that that entity has acquired the status of statehood. This is due to two main reasons: one is the above requirement of members to be states, and two is the element of recognition in being a UN member. When an overwhelming majority of UN members accept the entity as a state, it shows something. If we look at history, Switzerland was there as a state for a long time, but Switzerland got admitted to the UN in 2002 fearing negative externalities of voting. Nevertheless, membership to the UN is a strong indicator of statehood but not an absolute one. The starting point for the discussion of criteria of statehood is Article 1 of the Montevideo Convention on the Rights and Duties of States, concluded in 1933. The specific article lists down the criteria of statehood. Article 1. The state as a person of international law should possess the following qualifications: A permanent population, B, a defined territory, C, government, and D, capacity to enter into relations with the other states. Extract from the Montevideo Convention, 1933, on the rights and duties of states. A. Permanent population. Q. Do we consider people migrating from one territory to another as permanent population? Countries such as Afghanistan, Pakistan. When we say permanent population, we are not here requiring a certain population to live in a certain place without moving here and there. But one thing is important here. 28. PHE. These people have to identify themselves with a certain piece of land. For example, the Borana Oromos migrate to Kenyan territory, but they always identify themselves as the Ethiopian Borana. Therefore, there should be some population linked to a specific piece of land on a more or less permanent basis. It is not a requirement under international law that people should be living in a certain piece of land forever, it is rather more of a psychological attachment. It is not clear whether the requirement here implies the population has to be indigenous. The current understanding is that there shouldn't be a requirement of indigenous population. Q. Does size of the population matter? No. Countries like Tuvalu, 9,893 people, San Marino, 31,595, Liechtenstein are states regardless of the size of their population. B. Territory. A defined territory is one of the requirements. Thus, a state must have some definite physical existence that makes it clearly distinguishable from its neighbor. This requirement doesn't, however, indicate that the territories of a country must be certain. It should be defined, but not all of the country's territory should be clearly demarcated. For example, Ethiopia has a defined territory but still have an uncertain issue of border demarcation with Sudan. Other examples could be the issue of Kashmir between India and Pakistan. There must be some territory which must be undoubtable belongs to that entity. Similarly, an existing or emerging state's territory being subsumed by another state doesn't leave the country losing its territory from losing its statehood status. For example, Kuwait was fully annexed by the Iraqi state led by Saddam Hussein in the 1990s, however Kuwait did not cease to be a UN member. Size of the territory as well doesn't matter because we have countries such as Maldives, Tuvalu, Liechtenstein, Nauru and other microstates are still recognized states as long as they fulfill the other criteria. C. Government. In order for a state to function it must have a government. And not just any government but a functioning and effective government. Effective government implies a government having the capacity, the power to administer at least certain part of the territory and 29. PAGE. Capable to discharge functions of a government. The executive members of the entity must be able to exercise effective control over a defined territory and a permanent population. But international law doesn't require a state to have an absolute and an entirely dominant government. The government must be able to handle and administer the affairs of the country under the international arena. The absence of an effective government doesn't result in loss of statehood. Once a state is created, the fact that a government has lost effective control doesn't deprive a state of its statehood. For example, the federal government of Somalia controlled no territory in Somalia in 2006. D. Capacity to enter into relations with other states. It is generally understood as implying independence. When a country is independent, it would have the capacity to interact with other states. We are not talking about factual independence but rather legal independence. The fact that countries are economically dependent and thus receive aid doesn't imply that they are not states. For example, Hong Kong is not legally independent as it's part of China because of a treaty between China and Britain. Lecture 9.2. Recognition. Recognition is mainly a political act because in municipal laws, national legal system, there isn't a legal standard prescribed for the recognition of another state, thus it is the political decision of the government. Therefore it is mainly the decision of the executive wing of the government, and once it is extended it would have legal implications. That is why we study recognition and its legal effects. For example, under the FDRE Constitution we don't have preconditions for the government to extend recognition or not. Malcolm Shaw, for example, refers to recognition as a confusing mix of politics, international law and municipal law. It's an act when these three things interact. We should note here that recognition is a unilateral act as a principle. Sometimes there could be multilateral recognition. Thus, when states willingly agree to recognize a state, it shouldn't depend on the recognition of other countries. Recognition deals with a variety of factual situations. When we say recognition, we are not only talking about recognition of states but rather also recognition of governments. 30. PAGE. Recognition of territorial claims, recognition of belligerent insurgents, recognition of national liberation movements. The legal effects of recognition are entirely different as regards to international law and municipal law. In the eyes of international law, when a country recognizes other state, that is a confirmation state that it considers the recognizing entity as a state defined under international law. Recognizing a state is like giving a state a benediction, approval that it considers it as an international legal act or person. For the recognizing state, the recognized state can bring claims on international legal tribunals, can enjoy immunities. But the effect recognition produces internal is a bit different. The courts within the recognizing state will start to give value to the laws and decisions of the courts of the recognized country, rule of reciprocity. Additionally, internally non-recognition implies that entities and persons from that country cannot bring claims in the state. This is also logical as the nationals of non-recognized states don't get the same rights of nationals of recognized states. A. Recognition of states. Recognition of a state acknowledges that the entity in question fulfills the criteria of statehood. It is a sign of approval that the criteria of statehood has been achieved in the eyes of the recognizing state. Legal effects of recognition of a state. There are two theories on the legal effects of recognition of a state. The first one is the constitutive theory of recognition, while the second one is the declaratory theory of recognition. Usually, it's in the context of recognition of states, however, they also have some utility in terms of recognition of government. The constitutive theory of recognition asserts that a state's nor a government doesn't exist for the purpose of international law until it is recognized. For the proponents of the constitutive theory, it is only after an entity is recognized that it will become an international legal subject. They claim recognition has a legal effect, it establishes a state, it has the effect of giving an entity the status of a state. In this case, recognition is a necessary condition for the establishment or creation of state. Even if an entity has territory, population, government, capacity to enter into relations, if it is not recognized, it cannot be recognized as a state. For this theory, recognition is an indispensable part or element of statehood. 31. PAG. The declaratory theory recognition holds that recognition has no legal effect. The existence of a state or government is a question of pure fact, and recognition is merely an acknowledgement of this pre-existing facts. There is an objective criteria, and following this objective criteria, if a state ticks all the boxes, then that is it. Yes, states recognize other states or governments, but for the declaratory theory, states do recognize other entities not to enable them to exist as a state, but to rather to simply approve that all the requirements have been made. Recognition is a post facto benediction. Recognition amounts to acknowledgement of facts. An acknowledger doesn't decide, it testifies. One segment, faction, of the declaratory theory states that if a state fulfills all the objective criteria, then all the states are obliged to recognize. However, this is not totally true, as we have initially said that recognition is a unilateral act. Q. When a country denies recognition, does it necessarily mean it recognizing state thinks that the entity has not fulfilled the criteria under the Montevideo Convention? Recognition is more of a political act than a legal act. The recognition of states are at times motivated by the political calculation of the recognizing state, and very rarely does it reflect the actual fulfillment of the criteria. For example, China has refused to recognize Taiwan for political reasons rather than legal ones. Similarly, African countries, being economically influenced by China, have refused to recognize Taiwan. Therefore, leaving the status of an entity's statehood under the mercy of other states is unfair. Generally speaking, the declarative theory is the most dominant theory of the two. Under Article 3 of the Montevideo Convention, it is clearly stated that the political existence of a state is independent of recognition by other countries. There are times when the constitutive theory works perfectly, but it is the declaratory theory that is dominant in the majority of the cases. In dubious cases where an entity has fulfilled the requirements, then recognition has a constitutive effect. However, when the fact as to whether an entity has fulfilled a requirement or not is crystal clear, recognition has a declaratory effect. When Germany was divided into two East and West Germany, the creation of East Germany had disappointed many Western states because they didn't expect Russia to establish such part as an independent sovereign entity. These countries thought the creation of East Germany was unlawful, so despite the country clearly fulfilling all the criteria, they refused to accept or recognize East Germany. 4. 32. PAG. Countries belonging to the socialist camp, there was an easy recognition. However, for the West, East Germany did not exist for a long time. East Germany did not exist for a long time as Western countries were no certain as to whether East Germany had truly fulfilled the criteria of statehood. East Germany came to be recognized as a state only after the extensive recognition of Western states. Thus, we can claim that here the recognitions had a constitutive effect. Thus, it is in dubious cases that we see the importance of recognition. In dubious cases, you should expect an overwhelming recognition to be considered a state. One of the criticisms of the constitutive theory is how other states can decide the fate of another state to become the subject of international law. Shouldn't it be international law itself? The other criticism is how many states should give recognition for a country seeking recognition to be recognized. The constitutive theory doesn't provide an answer to this question. Palestine has over 135 recognitions, but is it a state? If we follow the constitutive theory, an entity would remain a non-state entity having fulfilled all the criteria and consequently devoid of international legal rights and obligations. Therefore, does it mean it can use force, as it is not subject of international law? Practically, that is not the case, as countries assert that it has to abide by the principles of international law despite not being an actor. For long the US did not want to recognize North Korea but still asserted that North Korea should not attack it. The Pueblo incident. B. Recognition of governments. Recognition of the government implies that the regime in question is in effective control of a state in the eyes of the recognizing state. When a new government comes into power in an existing state by a violent, unlawful or a non-constitutional means, the question of recognition of government arises. If there is a constitutional change of government, there is no need for recognition of government. States have often used recognition of government as a tool or instrument of policy. The U.S. has often regarded recognition as a mark of approval. U.S. has refused to recognize Hamas in 2006. Refusal to recognize a government sometimes is based on the belief that the government is not in effective control of the territory it claims to govern. There are also other reasons for non-recognition. The U.S. has under various circumstances refused to recognize governments for reasons other than lack of effective control. This is a clear embodiment of the political and unilateral nature of recognitions. 33 PHE. In the past, recognition of government had the effect that the recognizing state approved favored the recognized government. Because of this, the doctrine of non-recognition evolved. The doctrine is also known as the Estrada Doctrine, after the Secretary of Foreign Relations of Mexico. To avoid such misinterpretations that recognition of government implies approval of the regime, the theory of non-recognition dictated that states should never expressly recognize government. The simple commencement or continuance of relations is sufficient. The Estrada Doctrine dictated that an express recognition of government should be withheld. So instead of the country recognizing the entity expressly, it would start diplomatic relations with it. But the problem with the Estrada principle was that what replaced express recognition amounted to be implied recognition, which is hard to determine. International law considers some behaviors as implying recognition. For example, when a new government comes into power, if the prime minister or president of that state formally send a congratulation message, it should be regarded as an implied recognition. Q. Is bilateral trade or non-trade treaties imply recognition? In the case of multilateral treaties, it is very simple, as the relationship is not one-to-one, it doesn't imply recognition. However, in the case of bilateral treaties it is more contentious. Establishing commercial ties alone, however, wouldn't lead us to confirm the existence of an implied recognition. In international law, the establishment of a full diplomatic relation is the only unequivocal act from which full recognition can be inferred. Malcolm Shaw. The basic difference between the two, recognition of state and government, is that recognition of a government is made necessarily as the consequence of accepting statehood of an entity which the regime is governing. Recognition of a state can be accorded without accepting the regime with effective control. Recognition of government necessarily implies recognition of the state. However, when a country recognizes a state doesn't mean that it has extended recognition to the government. De jure and de facto recognitions. The distinction between de jure and de facto recognitions usually arise in the case of recognition of government. It makes sense in the case of recognition